Thanks, Chairman, and thank you, Attorney General, for being here. I appreciate it. Good to see you. Methane is probably one of the most dangerous greenhouse gases. We see plumes of it miles long floating across the United States. It takes multiple levels of enforcement, federal, state, local, and private, to address these massive leaks. What can you tell me you are doing to assure that there is that coordinated multi-jurisdictional enforcement operation in place?
You are exactly right, and we now have the benefit of overhead commercial satellites, which are able to actually see methane with respect to the infrared spectrum. So we are in the process of establishing a working group between our Environment Natural Resources Division in the Justice Department, the EPA, the Interior Department, and affected U.S. attorneys' offices across the country to make use of the tools, the scientific tools we have, and also some of the funding that was provided in the Bipartisan Infrastructure Act.
That is good news, and I hope that that effort will include advisory participation from state law enforcement, from local law enforcement, and from private litigant experts in this space.
Well, all of our work in the law enforcement field involves partnering with state and local law enforcement. Always happy to have expertise provided, but our law enforcement working groups are confined to law enforcement as a general matter.
I just got a document from a insurance publication that says, I'm just reading here, at least 1,375 climate change-related lawsuits have already been brought in the United States. These include suits filed by local municipalities and by states. Rhode Island is one of them, as well as shareholder suits. Given all of that government litigation taking place in this space, I would ask you, is there anyone looking at federal DOJ involvement in that area in the Department of Justice, and if so, who is that person?
So I really don't, as a general matter, want to describe our internal decision-making processes on these. I can assure you that the Environmental and Natural Resources Division has taken a very close look at this question. But beyond that, I really can't say.
Okay. Well, you may recall that the last time the Department of Justice took a really close look at this question, they got the standard of decision wrong. Applied a criminal standard of review to civil litigation. So I hope that the seriousness of the look that's been taken, what I would like to call an honest look, is actually in fact taking place, because the record from before your time is not very convincing.
I agree with you, Senator, that the criminal standard beyond a reasonable doubt is not appropriate for fraud cases.
Yeah.
Correct.
I'm
sorry, for civil fraud
civil
cases.
fraud cases, correct. Criminal cases. Congress right now is on the wrong side of a bunch of OLC opinions that relate to executive privilege. And there are some specific ones that relate to so-called absolute immunity that are on the books at OLC that have been specifically rejected in quite forceful language by actual Article 3 judges. And yet, those OLC opinions are still on the books. They're still available to other agencies who are making determinations about whether to block congressional oversight based on those OLC opinions. I would like to ask you, let me go back a step. OLC says that they don't ordinarily review opinions of their own even after they've been discredited by Article 3 judges, unless they've been asked. And you're one of the people who can ask them. So I'm asking you, will you ask them to review the OLC opinions that are now publicly on the books of the Department of Justice that have been discredited by specific findings of Article 3 judges? They relate to absolute immunity.
So my understanding of the long-standing process at OLC is not to reevaluate old opinions unless they are now relevant for a current controversy.
That's the problem.
And I also believe that their process is that if a court of ultimate jurisdiction determines that they are wrong, then they will evaluate it. My understanding of the
So
case.
Ketanji Brown Jackson was one of the authors of one of the opinions that said the OLC opinions were wrong. She's a pretty credible judge, I think. She's now sitting on the United States Supreme Court. And those OLC opinions hang out there for review by other executive agencies, even if there's no direct ask to the department that would trigger that OLC review. It's sort of like executive branch jurisprudence that sits on its own, independent from Article III jurisprudence. And somehow we've got to figure out how to connect those two things, because at the moment you have OLC opinions that appear to be flat out wrong by the determinations made by those whose job it is to say what the law is, the Article III judges, and there's no effort to ask them in that fairly unique circumstance to go back and fix it.
So again, I think all the circumstances you're talking about individual judges, sometimes a single judge on a court of appeals, sometimes a judge speaking in dicta, but no decision. If there were a decision of the United States Supreme Court that was inconsistent, or of a court of appeals, I believe OLC would reevaluate. Otherwise, there are lots of judges who criticize OLC opinions, and the Justice Department, as a former judge, that's perfectly appropriate for Article III judges to do. But we have to allocate our resources to cases which are active cases, and that's what OLC does.
Well, I will continue to pursue this because I think it is wrong for OLC to insist on developing its own jurisprudence that is separate from and independent from what Article III judges decide. And if the only way you can change an OLC opinion, which is controlling on the entire executive branch, is to get the Supreme Court to overturn it, then you've created a really lasting obstacle to the proper separation of powers in our Constitution. So to be continued. Attorney General, thank you for being here today.
Thank you.